Who's out there? All right, good morning, everyone. We're here for criminal motion hearings this morning. We have Ms. Benio from the state. Good morning. All right, we have one person right now in the courtroom. Sir, if you could come up. What's the last name? What was the last name?
All right, on two, bottom of page 2. Oh, right,
with Ms. Woodley. I don't think we have Ms. Woodley out in the hall.
I think she stepped out.
Okay.
I don't see that it's not real interpreter, but if you need, I can do my best to translate for you.
Oh, okay. All right. Good morning, Ms. Woodley. Are you ready to call a couple of your cases that are in the courtroom?
Yeah, sure. Yes, Your Honor, I'm ready.
Okay, go ahead.
First on my docket is Azard in 20MM2130. He was found incompetent by Dr. Collins in a report on February 1st of this year. I sent it over to the judicial assistant. I'm not sure if you received that report or not.
When did you send it?
I'm sorry, what was that, Your Honor?
When did you send it?
I just sent it last week because I wasn't sure if you had received it or not. Because it looked like the doctor had emailed it or tried compiling it.
Do you have a copy?
I can get you a copy. I can email it to you or print it here.
I don't see it in the court file.
It would be, well, I can print out a copy for you.
I don't think we have a printer in here.
Judge, I do have a copy of it. Would you like me to forward that to you?
Yes, please.
You tried to email it to you, Ms. Bonilla.
You did email it to me on Monday. That's what I
Maybe I
did.
didn't email it to Ms. Gilmore. So typically, once they're found, and I apologize, once they're found incompetent, at the year point, I file a motion to dismiss. I mean, I would ask the state to dismiss now, but traditionally, what we've been doing is putting them out for status at the year mark, and I file a motion to dismiss at that point. I'm not sure the state's position on what they want to do.
And that is the state's position, Your Honor, that we set this for status a year from now. And if Ms. Woodley chooses to file a motion, we can trust it.
All right, give me a moment to review it.
Ms. Woodley, do you have an order? I didn't have it.
All right, Ms. Woodley, do you have a proposed order?
Since Ms. Finney hasn't seen it, if I could email it to her first, and then after she has a chance to look at it, then I'll email it to you.
All right. All right, I'll make a finding that the defendant is incompetent to proceed. And how far out do we want to set this?
You can either do 6 months or a year, whichever I'll prefer to the court in the state.
The state will prefer a year. It's this way give Ms. Woodley time to continue to assess the case and file her motion accordingly.
I think the court would prefer 6 months. So do we have a date in August we could set this on?
And also that should then currently set for pre-trials for the 25th as well.
All right, let's cancel the 25th
Okay.
and go to, we have a pretrial in August that you can see. Oh no,
August 19th.
all right, August 19th at 9 a.m. for a status. All right, thank you, Mr. Azord. All right, you have another case in the courtroom, Ms. Woodley?
Yes, I think it's useful, but I'm not sure we can do for today. Living, thought it was going to be actually a trial.
Okay. All right, let me go to Zoom then. Let me go to, one moment here. Right. Let me go to Mr. Russo. It looks like you've got one case on 9 o'clock. Good morning.
Yes, good morning. I have one case. It's Angelica Antonio, case number 21CT291. There's a plea in absentia in the court file.
All right. Give me a moment to pull that up. All right, I do see the plea in absentia in the court file. Looks like the terms of the agreement are a withhold of adjudication, a $100 fine, all court costs, including costs of prosecution.
That's right.
Okay. All right, Ms. Russo, does your client need some time to pay?
Yes, please.
All right, I'll give him 90 days. All right, give me a moment to review the plea in absentia. Ms. Benny, have you had an opportunity to review the plea and absentia forms?
Yes, Judge, I've reviewed them and there's no objection to that.
All right. Mr. Russo, will you stipulate to venue and a factual basis for the plea and absentia?
Yes, sir.
All right, I'll accept the plea in absentia, find it knowingly, voluntarily, and intelligently entered upon a factual basis and in the defendant's best interest, withhold adjudication, impose a fine of $100 plus all court costs, including cost of prosecution, give him 90 days to pay.
Thank you.
Thank you, Mr. Russo. Anything else today?
No, sir.
All right, thank you. Have a good day.
Bye.
All right, looks good. All right, let me go to, do I have Mr. Mangone present?
Yes, Your Honor. Good morning. Greg Mangone on
Good
behalf
morning.
of Hannah Miller, Your Honor. This was a DUI arrest in August, her first offense, and she pled to basically the minimum penalties. And I'm sorry, can you hear me, Your Honor?
I'm trying to turn up the volume. Give me a moment. We're kind of cutting out there a little bit. Okay.
Okay.
So you're here on Hannah Julia Miller, 20 CT 1568.
Yes, Your Honor. Motion to terminate probation. It was a first offense DUI from back in August. She successfully complied with all terms and conditions of probation. Confirmed that with the probation officer, Ms. Vila. Requesting termination, Your Honor.
All right. Ms. Bonilla, what's the state's position?
Judge, the state objects to the motion at this time. The defendant was just recently placed on probation about a month ago. She's only been on probation for a month. The plea offer called for 12 months of probation, where she can early term at 6 months. Here we have noted that not only did a crash take place in this case, There are also some concerns with probation and the short amount of time she's been on probation. She just went on probation a couple of weeks ago. So the state is asking that you deny the defense counsel's motion to early term.
Your Honor, Ms. Miller was just very diligent in addressing the issues after her arrest. She did some extensive counseling, not just, I believe, not just the standard DUI course, but some additional mental health counsel, if I'm not mistaken. She's in the Zoom chat room here, Your Honor. When we did that is correct. The plea offer was for the 12 months and terminate early. And when we entered the plea, I asked Your Honor to consider terminating early, actually after 3 months, 6 months probation with the possibility to term after 3, because we knew that she had already done some of these things. And at that time, it was agreed that she would just be able to move for a termination once she's completed the terms. And that's why I filed the motion as quickly as I did, because she did in fact comply with everything. And I encourage my clients to address these things sooner than later, and she did. There's really no other benefit really for her right now to be supervised.
Ms. Bonilla, I don't see in the judgment and sentence that there was a no early termination clause.
No, the initial offer that Ms. Bonilla made was for 12 months probation, terminate after perhaps 6. And when I went and entered the plea with Ms. Miller, and I told counsel that I would be asking the court to consider a shorter period of probation, I did at that time, and it was just agreed that, well, she was sentenced to probation and that she can move to terminate once she completed the terms. It got even better than we were requesting at the sentencing, honestly. But nobody's trying to pull a fast one on anybody here. It's just Ms. Miller complied with everything.
Sure.
Judge, I was not there when this case played out at the time in which the defendant went on to probation. Nonetheless, it is left open on the judgment sentence. Although the state does understand it is not indicated on the judgment sentence, it would have been presumed that early termination would have been allowed after a short period of time on probation. Judge, it's only been 4 weeks.
If probation can be ready on?
Yes, go ahead.
Brenda Torres, County Probation. The objection basically is we don't believe that 1 month and 4 days is enough to establish a path of sobriety. She has completed her conditions, most of them we did before, but we believe that more time would be better. We can basically say, okay, yes, she's not drinking, we don't have a BAC, she refused it, we don't know how much she was drinking out that night, so we just want more time to monitor her.
All right, thank you. Well, Ms. Bonilla, there are no presumptions when it comes to the judgment and sentence. It is what it is. All right, motion to terminate early is granted. Mr. Mangone, do you have a proposed order you can send to the court?
I do, Your Honor. I did send a proposed order to Your Honor's judicial assistant late yesterday afternoon.
Okay, all right. I'll get that signed when I get back to chambers then.
Thank you. Thank you, Your Honor.
All right, thank you. Have a good day.
Likewise.
All right, let me go to Mr. Verderamo. Good morning.
Good morning, Judge. How are you?
I'm doing well. How are you?
Hanging in. Got 4 on the docket this morning. I think they'll be fairly quick.
Go ahead.
Christine Marie White, 20 mm 1125. This is a request to expunge Ms. White's record. The petition has a supporting affidavit as well as the certificate of eligibility indicating that Ms. White is eligible to expunge her record. Check for $42 was forwarded to the clerk. I ask that you enter the order expunging Ms. White's record.
All right. I do see that the petition has been filed, as well as the affidavit and certificate of eligibility. Does the state have a position on the motion petition to expunge?
No objection to the motion.
All right, the petition to expunge is granted.
Judge, the order was sent to your judicial system on 28th of January, so
It's already been paid. Okay, all right, I'll check with Julianne to make sure we've received that.
okay, thank you. Next case is Cody Harrison and Brigodi, 19 MM 2488. This is also a request to expunge the record. Verified all documentation has been filed on showcase, which would include, most importantly, the certificate of eligibility indicating that the expunge is verified. All parties have been noticed, which would include the city police department, and request that you enter the order expunging my client's record.
All right, do you see the petition as well as the affidavit and the certificate of eligibility have been filed? The $42 has been paid. What is the state's position?
No objection to the motion.
All right, petition to expunge is granted.
Next case is Brian Savage, 20 CT 376. This is a request to terminate probation early. Mr. Savage resolved his case, was sentenced on a reckless driving. He was placed on 12 months of probation and allowed to apply for early termination after 4 months. We've exceeded the 4 months. All conditions have been completed. Verified all financial obligations have been met. I request that probation be terminated.
All right, Ms. Bonilla?
The state has no objection. Has spoken with probation. The defendant is complete all these conditions on probation for more than 3 months. Therefore, the state has no objection to the motion.
I couldn't hear, Judge. I'm sorry.
She has no objection.
Okay, that's great.
All right, motion for early termination of probation is granted.
The last case I have is Manuel Ramos. This is the state's motion to subpoena medical records on 20 CT 2524.
All right, Ms. Bonilla?
Yes, Your Honor, the state called this motion that we can have to go to medical records. There was a car crash involved in this case in which EMS responded. The defendant was transported to physician regional back in December of 2020. So the state would ask that the motion that relates to the DUI investigation.
All right, Mr. Bergeron, what's the defense position?
As we object to the motion, I understand the standard's extremely low regarding relevance. I will draw your attention to the booking sheet, which would be page 1 of the booking sheet, indicates that the driver had red bloodshot eyes. I'm reading the narrative bottom, second to last paragraph from the bottom.
Okay.
Red bloodshot eyes. The driver had a mask on, so he was unable to smell an odor of alcohol. The driver's understanding of what I was asking seemed good, except for the items described above. Now above, it deals with his speech was slurred at times, and the individual seemed sleepy. So I'd articulate that there's not a factual basis to support for probable cause that my client was under the influence of alcohol or controlled substance.
All right, Ms. Bonilla, any rebuttal argument to that?
I kind of agree with Mr. Ramos' argument to a certain degree. However, based on the indicative impairment, judge, he was taken to, EMS did evaluate him, so we would like an opportunity to look at those records along with whatever conditions we normally have so that we can determine whether there were other indicators.
Judge, I did my best to try to hear what Ms. Bonilla was saying, but
She basically said that there were enough indicators in the booking report to establish a nexus.
thank you.
All right, the motion to subpoena medical records is granted. Do you have a proposed order?
Yes, Judge.
Judge, I'd like to review the order before it's signed to make sure.
All right, Ms. Bonilla, will you forward a copy of that? You can give that back to her. Just give it. You forward a copy of that to Mr. Verderamo, and then email that to my judicial assistant. All right, thank you.
Thank you, Judge. Have a good day.
Anything else, Mr. Verderamo?
I believe that's it. 4 cases. Have a nice one.
All right, thank you. You too. Have a good day.
Bye.
All right, Ms. Woodley, are you ready to address your client that's in the courtroom?
Yes, this is the Rojas Rostel and Disney.
All right, case number 20. Go ahead.
20 MM 1067. He can be withdrawn his previous plea, not guilty, and sentenced with no contest.
Usted va a estar retirando su declaratoria de no culpable y va a hacer una declaratoria de no me opongo.
To the following agreed upon terms.
La oferta que se le ha hecho.
He's going to do a withhold of adjudication,
Su culpabilidad no va a constar.
court costs,
Costas procesales,
cost of prosecution,
honorarios de fiscalía
and public defender fees.
y honorarios de defensor de oficio.
90 days to pay.
Oh, and yes, if you have 90 days.
Y 90 días para pagar.
Sir, will you raise your right hand to be sworn?
Primero levante la mano derecha para ser juramentado.
Do you solemnly swear or affirm testimony you give shall be the truth, full truth, and nothing but the truth?
Solemnemente jurado afirma que el testimonio que va a dar será la verdad, toda la verdad y nada más que la verdad. Okay.
Is that a yes?
Quiero decir que sí.
Sí,
Yes.
Will you state your name for the record?
Diga su nombre para el acta.
Leovaris Rojas Garcés.
And your-
Leoganis Rojas Cancel.
And your date of birth?
Fecha de nacimiento.
Mes 10, día 3,
October 3rd, 1973.
Sir, you're here on a charge of trespass, which is a first-degree misdemeanor.
Señor, usted está aquí acusado por un delito de haber entrado en un lugar no autorizado. Es un delito menor de tercer grado.
Your attorney has indicated you wish to withdraw your previously entered plea of not guilty.
Su abogado indicó que usted desea retirar su declaratoria de no culpable y hacer una declaratoria de no me opongo.
Enter a plea of no contest and accept the state's offer to resolve your case today.
Y aceptar la oferta del Estado para resolver su caso en el día de hoy.
That offer again was a withhold of adjudication.
Esta oferta es
All court costs,
no va a constar todos los costos,
including cost of prosecution and public defender fees, would be imposed.
incluyendo los honorarios del Estado, de la Fiscalía y los honorarios de defensor de oficio.
I'd give you 90 days to pay.
Voy a dar 90 días para pagar.
If you need more time than that, you'll have to work out a payment arrangement with the clerk prior to the end of 90
Si
days.
necesita más tiempo, puede hacer un arreglo de pago con la oficina de los tribunales.
Is that the offer you wish to accept today?
Esta es la oferta que usted desea aceptar.
correcto.
Correct. Yes.
Are you pleading guilty or no contest?
¿Se declara culpable o no me opongo?
No me opongo.
No contest.
I have a plea form in front of me. Is this your signature on this form?
Tengo un formulario de declaratoria ante mí. ¿Es esa su firma?
Yeah.
Yes.
And by signing it, you've indicated that you've read it or it's been explained to you?
Al firmar ese formulario, usted está indicando que usted lo leyó o le fue explicado.
Lo leí y me fue aplicado.
Both. I read it and it was explained to me.
All right. Did you understand all of the rights listed on this form?
Usted entendió todos los derechos enumerados en ese formulario.
Okay.
Okay.
Is that a yes or a no?
¿Quiere decir que sí?
Sí.
Yes.
And do you understand that you're waiving those rights by entering your plea today?
Usted comprende que al declararse el día de hoy, usted está renunciando a esos derechos.
Sí, ya.
Yes, the lawyer explained it to me.
All right. Do you understand that your plea will be used against you in a deportation proceeding if you're not a United States citizen?
Comprende que si no es ciudadano estadounidense, esta declaratoria será usada en su contra en una audiencia de deportación. I understand that also.
Okay. Are you under the influence of drugs, alcohol, or medication?
¿Se encuentra bajo la influencia de drogas, alcohol o medicamentos? No.
Are you suffering from any mental illness?
¿Padece de algún problema de salud mental? No.
Are you satisfied with your attorney's advice?
¿Ha quedado complacido, contento con los consejos de su abogado? Yes.
Has she done everything that you've requested?
Ella ha hecho todo lo que usted le solicitó. Yes.
Ms. Bonilla, any additional questions from you?
El Estado no tiene ninguna pregunta.
Ms. Woodley, will you stipulate to venue and the factual basis for the plea?
Su abogado estipula que existe jurisdicción para la declaratoria.
All right, sir, I'll accept your plea. Find it knowingly, voluntarily, and intelligently entered
Ha sido hecha inteligentemente y con conocimiento de causa.
on a factual basis and in your best interest.
Existe motivo fundado para tal y es lo que más le conviene.
Withhold adjudication, impose all court costs, including costs of prosecution and public defender fees.
Su culpabilidad no va a constar. Le impongo cosas procesales, honorarios de fiscalía y de defensor de oficio.
We're going to have you step right over here to be fingerprinted.
Le vamos a pedir que pase para que le tomen las huellas digitales.
Thank you, sir.
Gracias, señor.
All right, let me go to Mr. Gregoza, who's also in the courtroom.
Your Honor, Chair Dennis, 20 MM 843, you're going to go to the plea.
Okay. Ma'am, will you raise your right hand to be sworn?
Yes.
And what are the terms of the agreement?
Adjudication, 12 months probation, early term after 4 months potentially, and milepost, and a restitution of Walmart amount of $222.37.
223,
233.27.
233.
227.35.
$227.30. $227.35. Okay.
Too many numbers.
Ms. Bonilla, is that offer correct?
Yes, I put off the correct, including a no trespass at Walmart. Walmart located at 11225 Tamiami Trail North, Naples, Florida, 34110, and court cost and cost of prosecution.
And was it an adjudication or a withhold?
Misadjudication.
Okay. And will you state your name?
Karen Hosen.
Ms. Denz, your attorney has indicated you wish to withdraw your previously entered plea of not guilty, enter a plea of no contest, and accept the state's offer to resolve your case today. That offer again was to adjudicate you guilty, place you on probation for a period of 12 months. You may apply for early termination after serving 4 months, provided all conditions have been satisfactorily met. As a condition of probation, you must complete the mileposts, ACF, or shoplifters alternative program. The court would order restitution to Walmart in the amount of $227.35. There would be a no trespass at the Walmart located at 11225 Tamiami Trail North in Naples, Florida, and all court costs, including costs of prosecution, would be imposed. Is that the offer you wish to accept today? All right. Do you have any questions about the offer? Are you pleading guilty or no contest? I have a plea form in front of me. Is this your signature on this form? And by signing it, you've indicated that you've read it or it's been explained to you. Did you understand all of the rights listed on this form? And you understand that you're waiving those rights by entering your plea today? Do you understand that your plea will be used against you in a deportation proceeding if you're not a United States citizen? Are you under the influence of drugs, alcohol, or medication? Have you ever been diagnosed with a mental illness? Are you satisfied with your attorney's advice? Has he done everything that you've requested? Do you understand that theft is an enhanceable offense, meaning if you're charged and convicted of this crime in the future, you could be facing higher fines, higher penalties, more jail time, or a possible felony conviction? And knowing that, you still wish to enter your plea? Ms. Bonilla, any additional questions from you?
No additional questions from the state.
All right, Mr. Gregoza, will you stipulate to venue and a factual basis for the plea?
Yes, I do, Judge.
All right, ma'am, I'll accept your plea. Find it knowingly, voluntarily, and intelligently entered upon a factual basis and in your best interest. Adjudicate you guilty. Place you on probation for a period of 12 months. You may apply for early termination after serving 4 months, provided all conditions have been satisfactorily met. You must complete the appropriate milepost ACF or shoplifters alternative program. The court will order the court will order restitution to Walmart in the amount of $227.35. No trespass at Walmart at 11225 Tammany Trail North, Naples, Florida. All court costs, including costs of prosecution. We're gonna have you step over here to be fingerprinted. You'll need to check in with probation today. Before you leave the courthouse, it's located on the first floor. All right, thank you. Thank you, Mr. Gregoza. All right, let's go. All right, let me go back to Zoom. And Ms. Woodley, you don't have any other clients in the courtroom, correct?
I'm not in the court.
All right. All right, let me go to Mr. Brown. Good morning.
Good morning, Your Honor. How are you doing today?
I'm doing well. How are you?
I'm fine. I'm fine. A lot of Zooming.
Yeah, right.
I have Brandon Corin, Judge, set for a plea in absentia, and we filed the appropriate documents. You should see it as the last docket entry. Mr. Corin signed the notarized plea, and there's a fingerprint card that was done by law enforcement in the state of Alaska. So it should be in order. The state's offer, subject to Your Honor's approval, was a withhold of adjudication, court cost, and cost of prosecution.
Right. And this is, I'm sorry, what? It's Corin, K-O-R-I-N, 20 mm 274. All right, I do see the plea in absentia form. And this is for counts 1 and 2. And it's a withhold of adjudication, court costs, and cost of prosecution on both offenses. Is that correct, Ms. Bonilla?
Yes, Judge, that's correct.
Does your client need some time to pay, Mr. Brown?
Just because he's actually a firefighter, he's out in the bush, as they call it in Alaska right now. Okay. So just so I make sure I get the message to him in time, I'd ask for like 60 days. I don't. All right,
60 days to pay. All right. Ms. Bonilla, have you had an opportunity to review the plea and absentia documents?
Yes, Judge.
All right. Mr. Brown, will you stipulate to venue and a factual basis for the plea and absentia?
We do, Your Honor.
All right, I'll accept the plea and absentia, find it knowingly, voluntarily, and intelligently entered upon a factual basis and in the defendant's best interest. For each count, I'll withhold adjudication, impose all court costs, including costs of prosecution, and give them 60 days to pay. All
Thanks
right,
very much,
Mr. Brown.
Have a great day.
All right, thank you. You too. All right, let me go to Mr. Delamar.
Good morning, Your Honor.
Good morning.
In the case of Emmanuel Vasquez Perez, 20 CT 1904.
Okay.
At a previous hearing, Your Honor, defendant, excuse me, had not shown up, unfortunately. Your Honor was gracious enough to continue it to today to allow him to appear. Again, we've had no luck in contacting him and informing him or speaking to him. Therefore, I would respectfully request to be allowed to withdraw from the case.
All right, you'll need to file a motion to withdraw.
Certainly.
Ms. Bonilla, what's the state's position in this case?
Judge, pending the withdraw. Being that the defendant is not here today, can we set for status to require his presence? Because
I think I required his presence for today.
I don't see it would ask for a bench warrant, Your Honor.
All right, bench warrant granted. Any comments on bond?
I would recommend, Your Honor, Judge, I would recommend a $1,000 bench warrant.
All right, $1,000 bond. All right, Mr. Delamar, once you get that motion to withdraw filed, then we'll set that for a hearing.
Thank you, Your Honor.
All right, thank you. Have a good day.
Likewise, Your Honor.
Thank you. All right, let me go to Mr. Mallow. Good morning.
Hello, Judge. Good morning to you. Judge, I have Yaelin Lucas Ruiz, Anthony Mayo on her behalf.
All right, 20 CT 1625.
Thank you, Judge. And I filed with the court a plea in absentia, and we'd like to be able to close the case out this morning.
All right, I do see the Ruiz, or it might be under Luque.
Okay, but I don't have any more.
20 CT 1625. It's under L.
Okay, thank you. What's the name of the attorney present for Mr.
Mr. Mayo, M-A-L-L-O. All right, and it looks like the offer is a withhold of adjudication, all court costs, including costs of prosecution.
That's correct.
All right, Ms. Bonilla, have you had,
That is correct.
all right, have you had an opportunity to review the plea in absentia forms?
Yes, Judge, they've reviewed documents and there's no objection to
All right, Mr. Mayo, will you stipulate to venue and a factual basis for the plea in absentia?
So stipulated.
All right, I'll accept the plea in absentia, find it knowingly, voluntarily, and intelligently entered upon a factual basis and in the defendant's best interest, withhold adjudication, impose all court costs, including costs of prosecution. Does your client need some time to pay?
Your Honor, yes. Would the court consider 90 days?
All right, 90 days to pay.
I'm sorry, what's the defendant's last name? I have to put it in the showcase. I have the last name, sorry, first name. Because I have Anthony Mayo, is that him?
Yes. Looks good. All right. Thank you, sir. Have a good day.
Good to see you.
All right. Let me go to Ms. Maurer. Good morning.
Morning, Your Honor. I have 2 plea in absentias on the docket this morning,
Okay.
in any order, whichever you prefer.
Whichever you prefer.
All right, well, the easier of the 2 is Paulina Chacombe. It's case number 20 CT 2437.
Okay.
And she is entering a plea to a withhold of adjudication, court costs, and cost of prosecution.
Your client needs some time to pay.
90 days, please.
All right, 90 days.
I left a blank on the plea in absentia for a fine because we were sort of in conversation about it when I was uploading, but there is no fine.
Okay. All right, Ms. Bonilla, have you had an opportunity to review the plea in absentia documents?
Yes, Judge, the plea offer in this case is correct. I have had an opportunity to review the plea in absentia. State has no objection to the documents.
All right. Ms. Maurer, we stipulate to venue and a factual basis for the plea in absentia.
I do.
All right, I'll accept the plea in absentia. Find it knowingly, voluntarily, and intelligently entered upon a factual basis and in the defendant's best interest. Withhold adjudication, impose all court costs, including cost of prosecution. And give them 90 days to pay.
Okay. The other one I have this morning is Alexander Bazidlo. It's case number 19 CT 2667. Everybody ready for terms?
I don't know. Madam Clerk, are you ready for the terms? Yes, go ahead.
Okay. It's an adjudication, 12 months of probation, 12-month license revocation, $2,000 fine, DUI school, substance abuse evaluation, follow the recommendations with random testing, 10-day vehicle impound, a victim impact panel, 2 years of ignition interlock, 60 days sober link, no possession or consumption of alcohol while on probation, court costs and cost of prosecution.
Let me ask you on the 60 days of sober link, when is that to begin?
Can we have up to a week for him to get it sorted out? They have to mail it to him since he's not in custody.
Okay.
The person who runs SoberLink, I believe, is in Sarasota, so they send it.
Any objection to requiring sober link within a week from today?
No objection.
Right, so sober link to be
Or just follow probation's instructions, something like that.
okay. Sober link to be administered within 1 week or upon probation's instruction.
Yeah, that sounds good.
All right, Ms. Bonilla, is that offer correct?
Yes, Judge, the offer in this case is correct.
All right, have you had an opportunity to review the plea and absentia documents?
Yes, I've had an opportunity to review Your Honor, state no objections to the documents.
All right. Ms. Maurer, we stipulate to venue and a factual basis for the plea and absentia.
I do.
All right, I'll accept the plea in absentia, find it knowingly, voluntarily, and intelligently entered upon a factual basis and in the defendant's best interest. Adjudicate them guilty, place them on probation for a period of 12 months. When are they to check in with probation?
They're calling to set up the orientation this afternoon.
All right. Defendant to check in with probation within 24 hours. 12 months driver's license revocation. There will be a $2,000 fine imposed. The defendant must complete as a condition of probation the appropriate DUI school, a substance abuse evaluation, and follow all recommendations. They'll be subject to random testing at their own expense. There'll be a 10-day vehicle impoundment, must complete 1 victim impact panel, a 2-year ignition interlock, 60 days of sober link, which must be administered within 1 week or at the instruction of the probation office. No possession or consumption of alcohol while on probation. That includes no alcohol in the residence, no going anywhere that primarily sells alcohol, such as bars, taverns, saloons, or packaged liquor stores. All court costs, including cost of prosecution, shall be imposed. All right, did I miss anything?
I don't think so.
All right, thank you, Ms. Maurer.
Thank you. Have a good day.
Thank you too. All right, give me a moment to review that. Within 24. All right, everything else looks good. All right, let me go to Mr. Hyder. Good morning.
Good morning, Your Honor. Matthew Hyder on behalf of Sarah Del Carmen Garcia Alonso. We're here on 2 CT cases where pleas in absentia were filed, Your Honor. One has some companion TRs.
All right, give me one moment here.
You might notice they might be under Mr. Jason Rios, my partner in your system.
Okay. I only see one case for her.
The 2 case numbers are 20 CT 2425 and 20 CT 1989.
Uh, 20 CT 2425.
No, that one's on.
Okay. The other one is 20 CT 1989. Could you bring that onto the docket?
Did that not get added, Your Honor?
It did not.
I apologize if that was our error.
That's okay.
Yeah, it's scheduled for April arraignment, so it probably hasn't been arraigned yet.
Okay. And what are the terms?
There, on page 2, paragraph 15, in 20 CT 2425, you'll notice it says it's a guilty plea to no valid driver's license. It's a withhold of adjudication and a fine of $200. And that's actually concurrent between both cases. Both cases.
Oh, I think you've gone on mute.
I'm sorry, Your Honor. I think I may have bumped the space bar. That's a first
okay.
for me on that one.
All right, last I heard was something concurrent.
Your Honor, it's a withhold on both and a $200 fine concurrent and concurrent. Well, I don't think court costs and cost of prosecution can be concurrent. So that would be separate because they're 2 separate cases.
All right, so withhold $200 fine, court costs and cost of prosecution on each case.
Your Honor, the only thing I'm trying to point out is that the fine itself was relayed from Mr. James Stewart as concurrent to both cases. So
I don't know what that means.
Maybe an easier way to say it is $100 fine per case, but what was relayed in our offer email said a $200 fine concurrent between both cases.
Ms. Benia? So $100 fine in each case?
Yes, Judge.
All right, withhold, $100 fine, court costs and cost of prosecution in each case. 90 days to pay?
That would be great, Your Honor. And it's just a matter of the TRs that's left. And I would just ask the court, the TRs that remain are failure to show registration and proof of insurance. Your Honor, I'd just ask for a withhold and a fine if you would be inclined.
I can't address the TR cases today.
Oh, that's totally fine. They'll just go on to another docket and I can address them then?
Correct.
Okay, that suits us fine, Your Honor.
Matthew Heider, Heider.
You said Heider?
Yes.
That's all I have, Your Honor. I appreciate you adding that one in for me.
Okay, no problem. All right, Ms. Benia, have you had an opportunity to review the plea in absentia forms?
Yes, Judge, I reviewed the documents and we have no objection to the documents.
All right, Mr. Heider, will you stipulate to venue and a factual basis for the plea in absentia in both cases?
Yes, Your Honor.
All right, I'll accept the plea in absentia in both cases, find them knowingly, voluntarily, and intelligently entered upon a factual basis and in the defendant's best interest. In each case, I'll withhold adjudication, impose a $100 fine, all court costs, including costs of prosecution, and give them 90 days to pay.
Sounds great. Thank you very much.
All right, thank you, Mr. Heider. Have a good day.
You too, Your Honor.
Thank you. Okay, that's good. All right, let me go to Mr. Meyer. Good morning.
Good morning, Your Honor. Ed Mayer on behalf of Jimmy Meza Cardona, Your Honor.
All right, case number 20 CT 1085.
Correct. Thank you, sir. Sorry, I was looking for that right now.
That's
Judge,
okay.
last time we were here, this is the case that we're trying to resolve with probation doing community service hours. The last time we were here, we were going to the church to pick up the documents. My client's wife got COVID. They all live in an apartment, and that delayed. I got the approval letter from the church. I don't know if Your Honor can see it, February 18th. So February 19th, I got him to sign everything. The church approved them for the hours. And yesterday on my account, I FedExed everything to probation. He's eligible to start this weekend with the church being cleared of the COVID and everything. He didn't get sick, but he was in the house with his wife who was sick. So the church didn't want to risk because he's distributing food as part of the community service hours. So I think we're finally there. My apologies to the court, Your Honor.
Okay. Ms. Bonilla?
Sorry, Judge, I'm checking to make sure.
Is this a diversion case?
It was sent to Charles Cruz, Judge, probation, if that helps.
Thank you.
No objection, Your Honor, if you can sign for diversion in the hours.
Did he not sign up for diversion?
That wasn't made clear to me. I thought he did. I don't know whether defense counsel indicated that he did sign up for diversion or not.
For a contract, I'm not, I didn't want to have to do that.
I could answer that, Judge.
Okay, go ahead.
Yes, he actually, what happens is this, they sent us a package from probation, and that's the package that I overnighted last night.
Okay.
So he should be getting it today by 4 o'clock in the afternoon. And we already discussed because the last time I sent the check with the wrong name on it. So Mr. Cruz gave me the proper way of doing it, and I dotted all the I's and crossed all the T's.
Okay, all right, I'm with you now. All right, so we just need to set this for a status, and it should fall off the docket.
Yes.
Okay. Let's go to March 31st at 9 o'clock.
Perfect, Your Honor. Thank you so much.
That it won't be there.
Yes, definitely.
All right. Thank you, Mr. Mayor.
Thank you, Your Honor. Thank you, State. Appreciate it. Be safe.
All right.
Thank you.
Thank you, you too. All right, let me go to Mr. Gorman.
Hello, Your Honor. Good morning.
Good morning.
Judge, we got two cases. First one is Sean Sweeney, 19MM 2487.
Okay.
This is defense's motion to expunge. He is eligible. The original certificate was filed with the clerk. Was a check was tendered to the clerk for $42. At this time, we'd move to expunge.
All right. I do see that the petition has been filed, as well as the affidavit and certificate of eligibility. I see that the $42 has been paid. Ms. Bonilla?
Judge, the state has no objection to the motion to expunge.
All right, the motion to expunge is granted. Mr. Gorman, if you haven't already, you'll make sure to have an order sent to my judicial assistant.
We'll do that immediately, Judge. Next is case number 19 CT 2474, Michael Itzkowitz. This is defense's motion for early termination of probation. Back in, been on quite some time, I believe it was June of last year, he pled to a DUI offense. Standard terms and conditions of the DUI. It was allowed that he may petition after 4 months. We've greatly exceeded that. He needed some additional time to get some of the tasks completed, but he is now, it's my understanding he's up to date on all fines, fees, and costs, and has completed all outstanding terms and conditions. At this time, we would move to early terminate.
Judge,
Yes.
per probation, I didn't discuss the case with probation. The state has no objection. All conditions have been made, fees have been paid, so the state has no objection to the motion.
All right. Motion for early termination of probation is granted.
Thank you, Judge. We'll send the order.
All right, very good.
Good day.
All right, thank you, Mr. Foreman, you too. All right, let me go to Mr. Levy. Good morning.
Morning, Your Honor. I'm here on one case, Dylan Leon Alexander's his middle name. Sorry, case number 20 CT 1037. This is a plea in absentia, Judge. It's been filed with the court. It's been sent to the state for approval. I believe the state is going to agree to amend the charge of DUI to a willful and wanton reckless driving. I can state the terms, or if Your Honor wants to do so, that's okay.
All right, Ms. Bonilla, do you have that statute number?
I can provide it, Judge, if you like.
Go ahead.
316.192(1)A.
Okay. What? They're telling me it's 2A.
Oh, we put 1A in the statute. I believe, let me double check. Two-way judge says, except as provided in subsection 3, any person convicted of reckless shall be punished. I mean, you know, 1A is any person who drives a vehicle in willful and wanton disregard for the safety of persons or property is guilty of reckless driving.
So it doesn't matter. It's 1A and 2A, right? That's what we're saying. Okay. All right. And so the terms include an adjudication of guilt, a $500 fine, 12 months of probation, which may be mail-in, with the possibility of termination after 6 months upon the completion of all conditions, appropriate DUI school, substance abuse evaluation, follow recommendations, 1 victim impact panel, random testing at the defendant's expense. The court will order restitution to the victim and reserve on the amount. No possession or consumption of alcohol, no entering bars, taverns, saloons, or packaged liquor stores. All court costs, including costs of prosecution, would be imposed. Ms. Bonilla, is that correct?
Judge, yes, the plea offer in this case is correct.
All right. Have you had an opportunity to review the plea in absentia forms?
Yes, Judge, I've had an opportunity to review the documents, and the state has no objection to the documents.
All right. Mr. Levy, will you stipulate to venue and a factual basis for the plea in absentia?
I will.
All right. To the amended charge of willful and wanton reckless driving, the court will accept the plea in absentia, find it knowingly, voluntarily, and intelligently entered upon a factual basis and in the defendant's best interest, adjudicate guilty, impose a $500 fine, place the defendant on probation for a period of 12 months, which may be mail-in. The defendant may apply for early termination after serving 6 months, provided all conditions have been satisfactorily met. The defendant shall report to probation within 24 hours. Must complete the appropriate DUI school, undergo a substance abuse evaluation, and follow all recommendations. The defendant will be subject to random testing at his own expense. Must complete 1 victim impact panel. The court will order restitution to the victim and reserve on the amount. There will be a no possession or consumption of alcohol provision. That means the defendant cannot consume alcohol while on probation, cannot have alcohol in their residence, cannot go anywhere that primarily sells alcohol, such as bars, taverns, saloons, or packaged liquor stores. All court costs, including cost of prosecution, shall be imposed. Ms. Bonilla, did I miss anything? All right. All right, thank you, Mr. Levy.
Thank you, Judge. I don't need to merge and dismiss the citations, correct? Because they're DUI related. There's a refusal citation and a DUI citation.
I do not see that, no. No.
Okay. Thank you, Judge.
All right, thank you. Have a good day. Yes.
I have to put the attorney of record that showed in court so the judgment reflects it.
LEVE.
Oh, we're doing. That makes sense. Thank you.
Okay, all right. Did you get mail in?
Yes, sir.
Oh, okay, there it is. Okay, looks good. All right, let me go to Mr. McGann. Good morning.
Good morning.
All right, I'll let you call your cases, Mr. McGann.
So there's only two of them. The first one, the last name is Aguila, A-G-U-I-L-A.
All right, case number 20 CT 696.
And he did complete all the documents and he actually mailed them out on Sunday. So I have not received them yet. So it would be our request for the March 1st non-jury trial docket for those documents to be filed or his appearance mandatory.
You want to go to the status instead, March 5th?
Sure, that's fine.
Any objection?
No objection, Your Honor.
Right, we'll continue it to March 5th at 9 o'clock for a plea in absentia, or in the alternative, the defendant's presence is required.
And then similar request would be for the next case and the final case I have, last name Gonzalez, first name Julio, 20 CT 1000.
All right. Any objection, Ms. Bonilla?
No objection, Your Honor.
All right, we'll do the same with this one. March 5th at 9 o'clock for a plea in absentia, or alternatively, the defendant's presence is required.
What's the defendant's name?
Gonzalez, 20 CT 1000. All right, anything else, Mr. McGann?
No, Your Honor, thank you.
All right, thank you. Have a good day.
You too.
Thank you. All right. Let me go to Ms. Roger. Good morning.
Good morning, Your Honor. I have Juan Lopez Garcia on your docket this morning. Judge, this was a motion to early terminate probation. However, yesterday I realized that I didn't include the motion to waive vehicle impoundment as well. He has signed an affidavit, and so the appropriate paperwork has been filed. I know that that motion wasn't scheduled. If we can consider it this morning, great, or if Your Honor would prefer me to reset it, I can do that too.
I see the motion to waive the vehicle impoundment, but I don't see the motion to terminate probation.
I did the hearing on the 18th, the notice of hearing. I wonder if I e-filed the judge and it got kicked back to me for some reason.
Could be. I do see the notice of hearing.
Yes, Your Honor. I had,
Right.
I can e-file on an emergency basis and maybe it will go through.
Well, you want to just continue it to March 5th to the status docket?
Yes, Your Honor. What time is that?
It's at 9.
That would be fine, Judge.
All right. Any objection to that, Ms. Bonilla?
No objection, Your Honor.
All right. We'll continue the case to March 5th at 9 o'clock.
Thank you, Your Honor.
And that should be plenty of time to get those filed.
Yes, Your Honor. And then the last case I had was Michael Sullivan. He is set for a motion to waive vehicle impoundment and a motion to early terminate probation.
All right. And that's 19 CT 2596. And I do see both motions in the file.
And Your Honor, on Mr. Sullivan's case, he has complied with all of his terms and conditions. There have been no violations during his probationary period. And he also signed an affidavit to the effect regarding the motion to waive vehicle impoundment.
All right. Ms. Bonilla, what's the state's position on these two motions?
The state doesn't have any objection to the affidavit waiving vehicle impoundment. He did do a search and found that he does not own a vehicle at this time. So we have no, he is caught up to date with all his conditions. They have no objection to the both motions.
All right. All right. Motion to waive the vehicle impoundment is granted. Motion for early termination of probation is granted.
Thank you, Your Honor. I did provide your judicial assistant with proposed orders for those two motions.
Okay, very good. We'll get those.
And
done.
Judge, lastly, can I just address one quick thing? My client said he received a letter from the DMV saying that his driver's license revocation was for 1 year. And on his plea in absentia, it was only 6 months, but I think they told him that the clerk did not indicate on his judgment and sentence how long his revocation period was, so they automatically put it on for 1 year. But I did include in his plea in absentia originally that it was only for a period of 6 months.
I do see that it was not included on the judgment and sentence.
Yes, Your Honor. He just called me about that this morning. Is that something that I would need to set for a hearing, or?
Well, I think you'll need to file a motion to correct sentence.
Okay.
And if the state has no objection, then you can just send me a proposed order.
Okay, Your Honor, that will work. Yeah, it was left off the judgment and sentence by the clerk, so.
Yeah, we've had, I've seen that happen one other time also where it's not
Oh, okay.
on the judgment and sentence, and then they find out when they get a notice from the DMV.
Yes, that's
And
what happened.
We've had to go back and amend the judgment and sentence before.
Okay, Your Honor, I'll send you that.
All right, I'm sure the state
Thank you.
Probably won't have an objection to that, so you should just be able to send me a proposed order with that.
Perfect. Thank you, Your Honor. That's all I have. Have a nice day.
All right, thank you, Ms. Roger. You too.
Thank you.
All right, let me go to Ms. Fish. Good morning.
Good morning, Attorney Monica Fish. This is Estate versus Steve and Brown, case number 20 CT 669. This is a plea in absentia, and we have filed the documents. He'd be entering a plea of no contest, and he would be receiving a withhold of adjudication, $100 fine, court costs to be determined, and $50 cost of prosecution, 90 days to pay.
Is that correct, Ms. Padilla? All right. Have you had an opportunity to review the plea and absentia forms?
Yes, Judge, the state has no objection to the documents.
All right, Ms. Fish, will you stipulate to venue and a factual basis for the plea and absentia?
Yes, Your Honor.
All right, I'll accept the plea and absentia, find it knowingly, voluntarily, and intelligently entered upon a factual basis and in the defendant's best interest. Withhold adjudication, impose a $100 fine, all court costs, including costs of prosecution, and give the defendant 90 days to pay.
Thank you, Your Honor.
All right, thank you, Ms. Fish.
Bye.
Have a good day. All right, that's good. All right, and Ms. Woodley, you have another case?
We have one left on the docket. Dottie Branch, Treasurer in 15-2930. This was going to be a motion asking for a competency evaluation, but I would like to withdraw that motion at this time. She is, I do believe, based on my phone conversation as well as my colleague David Cooley's in-person visits with her, she is confident to proceed at this time. Even though she is at the Warren Center and underpaid track, she is ill, but she is confident to proceed. So I'd like to withdraw my motion at this time. There might be an issue why I can address another time about whether she can come to court, but for today's purposes, I'd like to withdraw my motion.
All right, motion for competency examination is withdrawn. All right, thank you, Ms. Woodley. Ms. Woodley, do you mind going with us to 3-4 for the next case? Because are we still going over there? Yeah. I'm sorry? Yes, we're going to 3-4. No, you don't, but we're going to address Mr. Casasa's motion to withdraw as attorney. And so if that's granted and she can't afford to hire another attorney, then I may make a temporary appointment. Okay.
I don't mind.
Okay. All right. In that case, I think the only case we have left to address then is Mr. Casasa, which we will take a brief recess and move